Moving on, we're going to look at another aspect within healthcare, and this is certainly something where at the state level we can be leaders. We're going to talk about tort reform. Tort reform really is based right now upon what we would call a blame and shame system. It is one that drives disincentives for physicians to do two things. One, to minimize the ordering of tests, to do those tests just that need to be done to diagnose patients. It leads to the practice of defensive medicine, which escalates costs. The second thing it does is it creates a level of disengagement between patients and physicians. Physicians have a tendency to start seeing patients as adversaries in this process. And by doing that, we do not do the things that our tort system is supposed to do, which is actually to bring about a level of medical justice to those who have had harm within the healthcare system. So we are very blessed and lucky today to have one of the preeminent leaders in tort available. This is Professor Joanna Shepard-Bailey. She is a current law professor at Emory. She's an associate professor, She teaches law, torts, and economics. She also does analytics and statistics for lawyers. She oftentimes testifies before Congress and has published in multiple law reviews, legal, and economic journals. She has a recent article, which I believe is available in the back, that is titled Justice in Crisis, Access to Justice in the Medical Malpractice System. And I hope you welcome and look forward to hearing what Joanna has to say.
Well, great. I'd like to echo the sentiment. Thank you to Kelly and for everyone for organizing this event and for having me speak to you today and share some of my latest research and ideas on this topic. So, you've heard a lot of criticisms of the medical malpractice system. Most of these involve money. The current cost nationally of the medical malpractice system is estimated to be about $59 to $60 billion. This includes the cost of not only the litigation and the damages that are paid, but also the exorbitant cost of the defensive medicine that I was just described as part of the system as well. I'm going to talk about a different thing today. It doesn't focus as much on money. It's about access to justice. So data shows, research shows that most attorneys reject over 90% of the cases that they screen. There's various reasons why they reject these cases. Some of the cases just are not good cases. The attorneys feel like they're unlikely to win them. Maybe in their heart they feel like it is a good case, but for whatever reason the evidence isn't strong enough that they feel like these are winnable cases. But a large part of the cases that they reject are just not economically feasible for the attorneys to take. So I know there's a lot of attorneys in the audience, and so this is not new news to you, and this is not new news to most attorneys when I talk about this, plaintiffs' attorneys at least. But there's various reasons why, especially a medical malpractice case, is often just not economically feasible for an attorney to take. One is the very high cost of medical malpractice litigation. I'll talk a little bit more about this. And another is that recent tort reforms that have given us a lot of benefits in the medical malpractice system that I'll also discuss have also reduced damages, which exacerbate the existing access to justice problem. So let's talk about litigation costs first. The current cost of prosecuting a single case of medical malpractice is estimated to be between $50,000 and $500,000. As you know, a contingency fee attorney pays this money up front, and then they are paid only if their patient recovers. They receive a percentage of that winnings, and that's how they pay for these litigation costs. There's a lot of costs. There's a lot of cases that attorneys take that do end up being a loss for them because their litigation costs exceed the damages that they recover. So this estimate, $50,000 to $500,000, obviously depends on the kind of case, the complexity of the evidence, and how much litigations there's going to be involved, how long and drawn out the litigation is. Most medical malpractice attorneys that we talk to, and not only myself, but other people who've written on this as well, have found that in general attorneys use kind of a rule of thumb of about $100,000. That going into a case, they expect the average case is going to be, $100,000 is kind of a good rule of thumb. If it's a particularly complex case, they'll estimate more. But that's kind of at least their baseline for starting. And so you can see here at the quote, there's kind of an explanation that the American Bar Association put out for why these medical malpractice costs are so expensive. There's a lot of money for experts. Doctor experts cost a lot of money. I'm always very jealous when I do expert work and the doctors are on the case because they're earning so much more than me. But the investigation, the depositions, everything costs a lot of money in these cases. So consider this as an example. So there's an attorney, a typical attorney often has a 33% to 40% contingency fee. That's the percent they make back if they win. Let's assume that expected litigation costs are $100,000. And again, this is just kind of a baseline. A lot of cases they would expect to have higher costs. This attorney only breaks even if damages are $300,000. Now, breaks even does not mean they make a profit, does not mean they pay themselves or their staff or anything else. It means that basically they cover their litigation costs, right? So this attorney, assuming that he expects litigation to cost $100,000 and he sees a case that's presented to him where he thinks damages are potentially $300,000, he'd be an idiot to take this case, right? No attorney in their right mind should take this case. Ideally, he would have expected damages quite a bit more so that he not only makes a profit, but he can pay his staff and I guess his mortgage and everything else that's important as well, his health care bills, everything else. So these cases just don't get picked up, right? No attorney in his right mind takes this case. It's not no negative to attorneys. It just doesn't make economic sense. They have to act like businessmen in order to make these decisions. So we see quotes from attorneys interview that they call medical malpractice the sport of kings. Only the correct kind of mix of damages and expenses have to present themselves in order for an attorney to be willing to take this case. I like the second one as well. The cake has to be worth the candle. I don't think I've heard so many different cliches to describe this scenario, but this is a new one for me. The cake has to be worth the candle. If expenses are high, they don't bother taking the case unless there's a likelihood of a very high recovery. So that's where we start with litigation costs. But then tort reform has provided a lot of benefits in the medical community, right? So another area where I do a lot of work on is tort reform, and especially medical malpractice tort reform. And the existing evidence all shows that tort reform reduces premiums. Because it reduces premiums and the fear that doctors face of liability, it brings doctors to states. So there's a significant body of evidence that shows that doctors move to states or offer more procedures in states where there's tort reform because their costs are lower. They're not as afraid of as much liability. Similarly, there's just other evidence that tort reform just improves the economy as a whole. But there's one thing that tort reform has actually made worse, and that's this access to justice problem. So I'll show you with an example, and then we can talk a little bit more about it. Assume we have a potential plaintiff, victim of medical malpractice. Economic damages are $50,000, so this is their lost earnings, their medical costs, and then non-economic damages might be $500,000. So they've received some horrible injury where for the rest of their life they're going to suffer pain, embarrassment, disfigurement, whatever, and so non-economic damages are quite high. An attorney with a 33% contingency fee, if these damages are $550,000, will earn $181,000, right? So that's 33% of the winnings. So this attorney, again, to break even, as long as he doesn't think litigation costs exceed $181,000, he'll make a profit. He might take this case. Again, for a very complex case, he may not. If he expects the litigation costs might be as high as $500,000, which is the upper bound on that estimate, he wouldn't take this case as well. But at least for kind of the baseline $100,000 cost, he should take this case. Now damage caps come in, a $250,000 cap on non-economic damages, let's say. So suddenly the attorney with a 33% contingency fee only earns $100,000, right? Total damages will now be $300,000. His contingency fee is $100,000. That's exactly what his baseline expectation of litigation costs are. So now he doesn't take this case. So for all the benefits that tort reform has given us in terms of more doctors, lower premiums, there's actually zero empirical evidence that medical malpractice tort reform worsens health outcomes, and there's actually a growing body of evidence suggesting that it actually improves health outcomes for certain vulnerable groups where access to medical care is a problem without tort reform, but it becomes more available when tort reform is available. There's all those benefits that tort reform gives us, but there's one thing that it has actually made worse, and that's this access to justice problem. So again, quotes from attorneys, if it's a case that's going to have to be tried in the upend, I think what that translates to is the expected recovery is $200,000 to $250,000, which is a $100,000 fee. We're not going to risk $100,000 in litigation costs to get a $100,000 fee. You can't do that in this business if you expect to be around very long. So again, this is just economic sense, right? I don't mean to say a negative word at all about plaintiffs' attorneys. This is the business that they're in, and they have to consider their costs and their expected benefits when they are considering taking cases. So research also shows that this access to justice problem is worse for particular groups, especially those that have lower economic damages. So because the expected recovery is lower, again, it makes attorneys less willing to take those cases. The empirical evidence shows that females, children, the elderly, demographic minorities, and the poor have the hardest time finding legal representation to take their cases. And tort reforms actually have made this problem worse as well, because tort reforms typically target non-economic damages, but not economic damages. Those groups listed right there, females, children, the elderly, demographic minorities, and the poor, tend to have a larger proportion of their award comprised of non-economic damages instead of economic damages. So it's capping a larger portion of their award, which then again makes it harder for them to find legal representation to take their a lawyer to take their case. So, one more quote, tort reform has essentially closed the courthouse door to the negligence that would kill a child, a housewife, or an elderly person. The reason is that there's no medical expenses, no loss of earning capacity. So plaintiffs' attorneys recognize this. This is not new news at all to them. So in my study, I conduct the first national survey that focuses on this access to justice problem to really try and get a handle on how large of a problem it is, how many legitimate victims of medical malpractice are not finding legal representation and as a result not being compensated for their injuries. It was an online survey, 35 items. I had 464 responses, relatively equally split between plaintiffs' attorneys and defense attorneys. It was a national survey, and I'll talk for you in a second about the Georgia survey as well, but this one had responses from 39 different states, and it was very representative in terms of office location, firm size, experience in med-mal cases, and case disposition. So basically, there's no reason to think that the attorneys that responded are somehow a different group because they look much like the national sample of medical malpractice attorneys. So the first thing that I found is I asked what percentage of the cases that you screen do you reject? And so these are various numbers. But the important thing here is that 77% of the attorneys responded that they reject over 90% of the cases that they screen. Other studies that haven't specifically focused on access to justice, but just on practice patterns of medical malpractice attorneys have found very similar results. About 3/4 of attorneys typically respond that they reject about 90% of the cases that they screen. The reasons for rejecting cases, I asked various reasons, and again, this is just for medical malpractice cases. Obviously, a lot of these cases are rejected because they're not good cases. We've already said that. So I don't mean to suggest that every potential plaintiff that comes to a lawyer has a great case, because a lot of them don't. I teach torts as well in medical malpractice. A lot of the cases are just not good cases. But the attorneys do respond. Over 50% of them say their main reason for rejecting cases over their recent experience has been for economic reasons. Either damages are not expected to be high enough. That's actually the single largest reason given. Insufficient damage is expected from trial or settlement. The second reason is the expense of bringing the claim. So economic factors are the number one reason why attorneys reject the cases that they do. And then I asked various questions trying to figure out if they had a rule of thumb threshold damage level below which they won't even look at a case. As soon as they figure out what expected damages are going to be, they reject the case regardless of kind of how strong the evidence. So the first question I asked them was just, on a relatively strong case, a case that you might win, the likelihood of winning on the merits is 51%. So it's not a great case, but they're more likely than not to win. And you can see that 70% of the attorneys said they won't even touch that case unless expected damages are $500,000. I next asked about a slam dunk case. 95% likelihood of winning, right? This is an easy case to win. Presumably litigation costs would actually be lower because the merits are so strong that it should be easier for them to win. And what we see here, and I don't know if when it just went red it became harder to read, but over 50% of the attorneys say that they won't take the case unless damages are over $250,000. And again, over 1/4 of them say they won't touch the case unless damages are over $500,000. So I also, in order to get kind of a handle on how tort reform has affected their willingness to accept cases, I asked them various questions about that. And the number one tort reform that was listed as reducing their willingness to accept cases were these non-economic damage caps. I gave you an example of that from earlier. So what does this mean? What does this mean for victims, for legitimate victims in medical malpractice? This is a big table, which as I tell my students, you won't be tested on the numbers later, but this is over the last 20 years, the median recovery for various kinds of injuries for various kinds of malpractice. And so I would, I guess, mostly pay attention to the column on the left, which shows different kinds of injuries, and then the different kind of median payouts that victims who have suffered these injuries have received in actual, where malpractice has been proven on the part of the doctor. And you can see a lot of these numbers are low. A lot of these numbers are much lower than that $250,000 and especially the $500,000 damage threshold that these attorneys use as their rule of thumb. Specifically, all of the areas in gray are below that 250 number, which means that if an attorney saw one of these cases where, you know, some of these significant permanent injury, right, even death, look at the bottom line, death cases, if they think that this is just a typical case, there's nothing extraordinary, we're not talking about Bill Gates, so we have a large economic damage component, we're not talking about somebody with a, you know, life, for the rest of their life will be, you know, severely impaired, the majority of attorneys aren't going to take these cases. They don't exceed these damage thresholds by which the attorneys can make a profit. In a second, you'll hear from a few people in the audience who I believe have experienced, unfortunately, what the bottom row shows here is that even in death cases where there was negligence, they could not find attorneys to take their cases. You're going to hear the relatives of the people, obviously. Okay, so we see, you know, what kinds of cases are left. Attorneys respond that the only good cases that they see, again, are either somebody with very, very high economic damages because they're a wealthy person who has lost a lot of work, hopefully, from their perspective, permanently lost from earning a high income, but at least if not permanent for a long period of time. Also, the other choice is a good case is anything where there's very serious permanent injury. Neurological brain damage, something that's permanent, a young person that has a long time to live with a long life expectancy, a brain damaged baby where there's long life expectancy that require 24-hour care. Those are the kinds of cases that attorneys are going to take. And obviously, from a kind of social perspective, these are probably the more important cases that deserve to be compensated. But it doesn't mean that all those other cases, especially the cases that result in serious permanent injury or wrongful death, don't also deserve to be compensated. So there's also been another survey of Georgia specifically, and Georgia malpractice lawyers specifically, a random sample of 63 attorneys, and the results look very similar to the national results, no surprise. 2/3 of the attorneys say they won't accept a case unless expected damages are at least $250,000. Almost half of the attorneys won't accept the case unless expected damages are at least $500,000. So this is not only a national problem, it exists in Georgia as well. The implications of this are very serious, as you can imagine. Many legitimate victims of medical malpractice do not find legal representation. As a result, they go uncompensated, right? They have no compensated for their lost earnings, for their future medical expenses. In turn, this very importantly reduces the deterrent effect of the medical malpractice system. We believe that the medical malpractice system provides a deterrent effect to doctors. It gives them incentives to reduce medical error and to take care. And the reason why it does that is because they fear this liability. But when there is no consequence of medical error because attorneys can't bring the cases that have resulted that are the result of medical error, it results in a lessening of this deterrent effect. So what's to be done? Obviously, tort reform, which again has achieved a lot of advances, has not eliminated this problem, has actually made it worse. There's a proposal floating around Georgia as well as other states. In addition, it's been enacted in various other countries and in very limited forms, covering very specific kinds of injuries in various states in our country as well, that would turn the current medical malpractice litigation system into something more akin to an administrative system, where there is less need for an attorney, it's less of a blame and shame system and more of like I hate to say workers' comp because there's a lot of negatives of workers' comp that this system, the proposals are hoping to improve beyond that, but it would be something more like that, where there's an injury, the person is compensated, it doesn't matter if their injuries produce $10,000 in harm or $100,000 in harm or anything less than what an attorney wouldn't take. And presumably that would not only achieve the benefits that the tort reforms have given us in terms of lower premiums, more doctors, better health outcomes, but in addition would lessen this access to justice problem that we're currently facing. Great, thank you.